Here we are. Good morning. Actually, it's afternoon, I think. Hey, Roger. Morning.
Morning.
Hey, Matt. Here we are.
South side of the building. No weapons.
Yeah, there we go. What'd you say, Roger?
No weapons. It says.
Oh, yeah, no weapons. Oh, shoot. You know, now that they told us we can't have weapons, now we got to leave them all here, I guess. Yeah. Okay. Yeah, pretty town. Beautiful place.
They were running a group called Feeding Families, which was one of the last pub structures to go open. And so they literally thousands and thousands of articles.
Hey, Chris, I got you. Could you just tell me what you just said?
On June 24th, skateboarded into Enbridge Line 6B in protest because of the way the day went out and because of communication with the police. I was never actually given a command to get out of the pipeline, and there was never a warrant issued for trespassing. So because of this, my charges have been dismissed not once but twice. Because they've been dismissed twice, prosecution is now seeking to retry me, so it's actually going to be the third time I get brought up on charges for the same action.
Triple jeopardy.
Yeah. Technically, it legally escapes double jeopardy because I haven't been found guilty.
Oh, I see.
So I don't know how many times they can keep doing it, but...
Huh. Interesting. Anything else we could add, you know, like how this is affecting your life, or you know, what anybody could do to help out the situation, if anything, you know, or like that?
I've had a swell of support for my action. I've been really lucky, and so what I would say for support is exactly what we're doing here today for the sentencing of these three. I got a much more fair judge than these ladies have gotten.
What'd you say?
I've gotten a much more fair judge than these ladies have gotten.
I see.
In my opinion.
I see, and so that's all the luck of the draw, huh?
It's the difference between counties. The police are paid by Enbridge here, so.
Oh, I see. Yeah, so I guess that does make a difference.
Yeah.
Well, it's good to see you. Yeah. And good luck on your run for Senate, right?
Yeah. Thanks.
Okay, man. Thanks again. All right. See ya. Hey, Roger, what's going on?
Bringing prisoners.
What's that? We'll bring prisoners still? Oh, I got you. I didn't see our girls.
No, here they are.
Let's go.
Quarter to one. Hi. How you doing, man? How are you?
It's a couple of things. So happy to see you. Again. Yeah, but I enjoy.
Maybe just a little low down because you told us a bunch of stuff about who you are.
Okay, let's go over here. We get some peace and light.
Yeah, thanks anyway. And then, so, you know, maybe you could just tell the rest of us, you know, who you are and what you do. And,
Okay.
yeah, cool. I see the camera. I know that you're going to be doing stuff for the national press. Did you want to fill us in at all?
Yeah. My name is Daymon Hartley, and I'm a a photographer and photo editor for the People's Tribune newspaper. And we're here and have been covering the trial and the three women, Vicci Hamlin, Lissa Leggio, and Barb Carter, who were convicted of trespassing and disobeying a lawful order of a police officer. Talk about an incredible travesty of justice. To be able to put people in prison up to 2 years for nonviolent civil disobedience directed at a criminal corporation like Enbridge, they're the ones who should be in jail. Good?
You bet. Appreciate it.
Hey, Roger. Let's go. Hey, Roger, can I see that card that you gave him? You know, I thought about that this morning, but then I forgot to bring mine. Hold it up right in front of you. You're all right, Roger. You're all right, man.
Everybody's attention. If you are not in this box over here, cameras, cell phones, video cameras, just put away there. You're out of here. You were told last night. Yes, you were. The judge ordered you. Are you with the press? Yeah. Let me see your ID. You got an ID with the press? No, with the press. I filled out the form. You have a form here. Okay, if you don't have, if you are not with the press and have ID, you are not in this box. You see what kind of ID you have? Okay.
We just filled out a form and was given a go. Okay. 5 minutes ago. Jeff was just here, just walked out. We're okay. I can't hear you.
If they tell you not to videotape something, don't videotape.
Okay.
Jeff. like this, say on a murder, an armed robbery, killing, multiple deaths, anybody bother to show up for any of that? I guess not anymore. Maybe if I had an animal that you're being tortured, I might get some. I got a case on that coming up. I'm sure I'll get you the numbers for that. That is People versus Barb Carter, 15-917FH. Ms. Murphy, how are you now?
I'm fine. How are you?
Good. We have a report that was prepared in this matter, and I have reviewed this, and I'm going to review that Ms. Carter has the same chance.
You have the winner.
I'm happy to make corrections.
Barbara is 22 years old.
Says 22.
She, I think that in a description of Barbara on page 1 of the evaluation plan, Barbara is referred to as a 23 years old. Barbara will be 23 this Friday.
All right. So that's almost 23?
Yes.
Go ahead.
My middle name is spelled with 2 M's at the end. That's not important, Your Honor. I have an objection to the scoring of 10 points for OB-19.
Okay, yeah, I understand the prosecutor was of the opinion that OB-19 should be scored differently than my opinion of that issue as well. Is that correct, Ms. Dixon?
That is correct, Your Honor.
So, did you receive a copy of the memo that she sent?
I did, Your Honor.
Okay, and your position is it should not be scored.
Yes, Your Honor.
My position over the years has been that it should not be scored. It continues to be my opinion because it's a total misuse of the law by the Court of Appeals. But I am bound, I think, by the rules that they've made. Wrong as they may well be in some situations, just like mine. So I think I have to move the 10 in.
Your Honor, if I may, we know that we disallowed it for Mr. Lawrence.
Yeah, that's before they showed up with some law.
Right. And I last night, Your Honor, looked at 29 cases on the issue of resisting and obstructing and the scoring of 10 points for OB-19. And I'd like to share with you some facts in the cases where 10 points for OB-19 was considered appropriate. People versus Ottman, I believe, concealing oneself and failing to turn oneself in. People versus Hubbard, the defendant fled in a stolen vehicle, resisted arrest, ran from police, and attempted to hide before finally being apprehended. People versus Briggs, the defendant ran from a police officer when commanded to stop and then hid from the officer after leading him on a brief chase. He interfered with the investigation of a crime. People versus Hurley, 10 points were allowed where the defendant threw away a gun, failed to walk backwards as instructed, failed to turn around, failed to get down on the ground. After being handcuffed, he tried to bring his hands forward under his legs. He used a breathalyzer. He was combative at the hospital. He spat at officers and had to be held down for a photo and forcibly returned to the police car.
I don't disagree with you. I understand that has been my position on the law for many years, but the way the case law reads is it's an automatic point.
No, Your Honor, there is case law where that it wasn't allowed in resisting and obstructing.
Recent case law? This is fairly new cases. These cases aren't like these old cases you're citing now. These are new cases.
No, the cases.
As I said, this is what the Supreme Court denied me.
The cases I'm citing are from 2013, 2012, 2011, 2011.
Okay. But I understand. But do you have any cases where it was denied?
Well, in the case that Ms. Dixon cited in her brief, People versus Hershey, it wasn't allowed where the defendant failed to make child support payments, and
well, that is a bit far-fetched. You want me to talk you out of it?
Your Honor, if I could talk about anything on the sentencing, that would be good. I haven't had my opportunity.
I know you will.
With respect to my memo, yes, there are some unpublished cases, but there's also a published case that was cited. I did not cite the case that Ms. Murphy stated. That was not a case contained in that memo. Something she got from further research, but not something I submitted to the court. I do believe that the actions of this defendant, as well as the other two defendants, was interfering with the administration of justice. The deputies, sergeants were not able to effectuate an arrest upon the defendants because the defendants refused to release themselves. Based on that, they had to bring out 21 additional members of law enforcement.
I understand all that. I did try the case, yes, but then I left your points in. I don't agree with you.
And if I could...
Now wait, I'm confused. I'm going to ask, is there any other corrections you want to make on your own issue file that you're going to you don't have to say?
Your Honor, we're Barbara and I are both new with this.
Well, ma'am, you know, I can't help you.
I know.
Look, I asked you if there's corrections.
Right.
Then I asked her if there's anything she wants to correct that she may have seen after she spoke to you. But since you were both
This is
back,
different from the elocution, correct, Your Honor?
yes, ma'am.
Okay.
Ms. Dixon, another correction.
Yes, Your Honor, just so the amount of restitution is correctly cited on page 3 of the report, at the bottom under victim's impact, it should indicate that in addition to the $3,500 for MSP, there is an additional $1,051.60. That is for replacement of tools and equipment. $1,051.60. Also, I had spoken with Emmerich, and they are not requesting any restitution. So the total restitution being sought at this time is $47,656.50.
All right. I'll put that in.
And the other correction I had, Your Honor, on page 4 in the defendant's criminal history, under 202 for the instant offense, the conviction date should be January 31st.
131. Okay.
No other corrections that we have for people.
Okay. Comment on sentence, please, ma'am.
Your Honor, when you read, as I think Your Honor has had a chance to read the character reference letter sent on Barbara's behalf, you see her as seen by those who know and love her. You see a caring, compassionate, and kind young woman, and intelligent and spirited young woman, but mostly you see a selfless and sacrificing young woman. Someone who, from the time she was a child, has made sacrifices in many forms for the good of others and for the greater good. When she was a little girl on a family outing in downtown Detroit, Barbara had $8 in her pocket and she gave all of it to a homeless person who needed it more than she did. And her own family, in which she's the youngest of 9 children, Barbara did whatever she was called upon to do to keep the family unit going. In church, she was an altar server. As a young adult, Barbara created 2 community gardens which she tends and she volunteers to feed the homeless. Barbara doesn't have a mean bone in her body. When she herself was harmed in her own neighborhood by someone who tricked her into letting him use her cell phone and then roughed her up and stole her phone, she did not respond with violence. And in fact, because she'd been a good neighbor to them, her fellow neighbors came to her rescue. You know better than I do, Your Honor, that Barbara is not typical of the people who stand before you for sentencing. Although she was convicted of trespassing, she did not trespass in order to engage in a destructive act. Although she was convicted of failing to obey a police officer, she did not do so in a way that put anyone in danger of physical harm. She didn't physically injure anyone. She didn't damage any property. In fact, she did what she thought was necessary to prevent further harm to people and further damage. There was no violence, and her actions were not motivated by greed, avarice, or personal gain. She acted out of love. With respect to sentencing,
we got enough people in here. Anybody else shows up, take it away. All right, thanks. Sorry.
With respect to the possibility of further incarceration, Your Honor, we respectfully suggest that further incarceration is not necessary. The probation department has not recommended it. The probation department didn't recommend it to Mr. Lawrence, although I understand he made the agreement. Your Honor did not impose it on Mr. Lawrence. The community will not be served by it. The community won't be served by Barbara being kept away longer than she's already been kept, but will rather be served by her re-entry into it so that she can continue to serve it within the confines of the law.
All right.
I ask that Your Honor be lenient and sentence Barbara to time served. If Your Honor is inclined to sentence Barbara to probation, I object to the probation officer's recommendation of 60 months and ask that a term not exceed 12 months. The report states that 60 months is recommended because of the high amount of restitution involved. And we object to the amount of restitution, Your Honor, and request a hearing on the matter. The stated justification is not adequate for numerous reasons. First, the law does not require it.
Well, I assumed we were going to have a hearing on restitution.
Okay.
We'd already talked about that.
Okay. So, as Your Honor is well aware, an order of restitution entered under the section for restitution remains in effect until it is satisfied in full. So it's not necessary for the defendant to be on probation for the entire time.
Actually, in a judgment, civil judgments, these people.
Okay.
So it stays on a credit record forever.
Okay. So Your Honor is well aware of his power to enforce the restitution order. If Your Honor is inclined to impose a term of probation, we ask that it not exceed 12 months, which is what was recommended for Ms. Hamlin and Ms. Leggio.
Yeah, I don't know why they didn't have the same agent.
I don't either.
This agent usually does very severe cases, so they must have been work or something. All right, thank you.
Okay.
Do you want to say anything? You're always happy.
Yes, ma'am. When I left down the equipment at the end of July, it was a gut reaction. It was an emotional response to the destruction taking place around me. I had realized over much thought that it wasn't the best tactic, and while I will stay committed to environmental justice in the future, over the past month I've had a lot of time to think and reflect, and in the future I will take my actions through more thoroughly, and I will act in a much more positive and respectful manner.
Thank you. Jason and John?
I think that the recommendation of the 60 months is necessary. I do think that a period of probation over 12 months would be a good idea to make sure that Ms. Carter stays on the right path. I'm glad that the time in custody has given her an opportunity to reflect and realize that maybe she didn't make the wisest choice, because as she occurred at trial, she was convinced that she would be doing this to stop the actions, and I think she knows that she's about proceedings. So I would ask that a longer term time, maybe 24 months of probation, would be appropriate.
If it is placed on 13 months probation, upon her release from jail, she's to obtain some sort of at least part-time employment within 30 days. She is to pay 130 Crime Victims Act fee. State cost is $118. That's for both cases, 50 and 68. Oversight fees $10 a month. There's a $500 court attorney fee. The restitution is noted, and the prosecutor will set up a hearing with the attorneys or work out some agreement on that. Defendant is sentenced to 36 days of jail with credit for 36 days. Defendant has a right to make an application for leave to appeal by filling out the appropriate forms. Applying for a lawyer at public expense within 42 days. Ms. Carter, good luck to you. Miss something?
Your Honor, did the court order attorney fees?
I put court costs because they have
Oh,
paid.
okay.
I'm sorry. I'm sorry. I had wanted to make the conditions of probation. Are you accepting the conditions that were listed in the PSIR? Or just
The
the
conditions
that you
of
listed?
probation are the ones that I state and sign in my order.
Okay.
Half of the stuff they put in here are things that I don't even understand why they're there. All right?
Thank you.
So what I say is what we
Thank you.
no one. You have a great day. Good luck, man.
I like that.
Oh, there's the rights form, Ms. Murphy. The green form to the fine, if you wish to recognize your automatic right of appeal that you can. 42 days. Next, please.
Madam, next matter for sentencing, People versus Vicci Hamlin.
Mr. Gage, you have both of these people who might be together.
Okay, just because I'm pinch hitting on Lissa Leggio.
He wants Ms. Hamlin. It was not necessary to file with the parent. Okay, People versus Vicci Rose Hamlin, docket 13924, FH. I wonder, Mr. Gagey, if you and your client had the same chance to review this that I've obviously done.
Judge, just for the record, it's Robert J. I'm sorry, I know it's difficult.
I won't do that. Go ahead.
I ran into it again and again, so I don't blame you. I have looked at the sentence report with his client, Your Honor. I've had opportunity to look at it, and I've got a few changes that are very minimal, just for corrections.
Go ahead.
The very first page, and Judge, I sent
You're
you.
retained. I got it. Right. I wrote it in.
The other thing I wanted to point out on the front page, there's an inconsistency with regard to the education of my client. It says 12th grade on personal history. She's got 2 years of college, which is reflected in the body of the
Yes,
report.
I saw that.
The other thing I wanted to point out, Judge, if you go to the actual evaluation plan, page 3, it's talking about the co-defendant people that I guess they're listed as co-defendants, the trespassers, misdemeanors. It says they all pled guilty to trespassing. Well, 4 of them did. They pled guilty to attempted trespass under a delayed sentence, delayed dismissal.
Well, I guess I got it.
Ignoring that, it's a no.
Delayed sentence.
Yeah, delayed dismissal, 3 months. They had to pay for the costs. Now, then I would just say this thing, Judge, and that's on the actual MDOC very report. It's not listed as appointed, which is incorrect.
You talk about BIR.
Yeah. And also, there's
Let me just find the right place.
third box down. Same thing on the second page for the misdemeanors. It's got the amount of those.
Got it.
Back on the first page of that basic information form, again, the very first box, which is the information about Vicci, it's got 00 on height.
Probably not a good item.
anticipate estimated weight? 140. 140. And again, it says 12th grade, and she actually got 2 years of college.
I'm sorry, what?
That's all the correction.
Okay. Any other corrections you saw, Ms. Hamlin? Dixon?
Your Honor, I did have the same additions I wanted to make with respect to the restitution amounts. To add in the $1,051.60 for an additional operation in state police. Again, no restitution being sought from Enbridge, and a total restitution being sought of $47,656.50.
And you want a hearing on that?
I'm asking for a hearing on that.
I put in the restitution reserve.
Pardon me?
I put in the restitution reserve for here.
Okay. And then with respect to the scoring of the guidelines, Your Honor, I asked that OB-19 be scored at 10.
You oppose that, Mr.
I do object. I've got a little different view on that, Your Honor, if you may elucidate on this for the record. I think the cases that the prosecutors set forth, while they may set forth an outer boundary, it doesn't say that you absolutely always nonstop have to score 10 points in OB-19 the way that I look at that. I think what that says, Judge, is that you still retain your discretion. There's not, I don't believe those cases stand for the proposition that says you absolutely have to score them. And the reasoning in those cases are interesting. They say, well, the legislature didn't say that you don't have to score it, like it says in some other provisions of the sentencing guidelines. And my point is that I'm laying down here, and I guess it's going to go to the Court of Appeals.
That's okay with me. I'd like to have a few of them come down to a trial level and fight.
I agree with that.
Yeah.
So, you know,
well schooled.
So I object.
All right. Well,
that'll get sorted out in the Court of Appeals.
As I said, my view is the same as yours. I agree with you totally, except I think the case law cited by the prosecution supports the position that these have to be scored. So, Ms. Dixon, you want to mention my record on that?
Yes, Your Honor, I asked that OB-19 be scored at 10. That gives us total OB of 10, which is the OB level 2. So the defendant is an A2, which makes the guideline range 0 to 6.
All right. Well, I made the correction. Your objection is more than Mr. Jakey. Ms. Jakey, how come your client has 41 days credit in the last year that you only have 34?
It says 27 days, and you know, that's something I missed. I was just sitting over there looking at Ms. Leggio's report. I didn't frankly do the math. I'm not too good at that, but it says on Vicci, it says that she got remanded on the 27th, and I think that's the day the trial started.
It's actually 34 days.
Yeah, I think that's right.
Yes, the remand was on the 31st, Your Honor.
So it's 34 days. I didn't understand why she would have been in jail any longer than 30.
Well, it's 34 on the...
well, the total's 34. Anyway.
Yeah.
All right, I had to point that out.
Yeah,
sometimes even I will.
I know you're reading the judge. And I know that you read the, I'm reading the application. I know that you read the sentencing. I guess my memorandum really was not a memorandum. It's true sense, other than title. I gave you those 6 letters of people that know me. And know her for quite a long time. And I was frankly taken aback by many of those letters, Judge, because I've got a very humble client here. She didn't tell me about a lot of that stuff that she did for the community, for her fellow members of society, which I think should be celebrated by anyone. That's what we want people to do. Creating food bank for the poor, working with elderly without any family, giving them comfort. Counseling with other people that have struggled with alcohol, which my client has managed to successfully keep out of her life. And we're struggling with that. And it carries over to her actions in this case, Judge. It's not consistent with a typical criminal that you're sentencing in your court. nor with the typical criminal client that I've represented in my past. And that's the big kind of example of, I would call it self-disservice. And I think that that's the difference in this case that I want to highlight. And I'm asking for the same sentence that the probation here recommends. Same sentence she just meted out to Ms. Carter, as well as Mr. Lawrence, and she'll be successful in confined state.
All right.
But she's a beautiful person.
Oh. Do you like to say anything there?
Yes. I did what I believe needed to be done on that day in July out of love. Love for my country, love for my world, love for my children and grandchildren, love for all God's children, and love for you, Judge, and your children. We are living in a dark time when criminals are rewarded and nonviolent protesters are imprisoned. In a more just world, Enbridge executives whose negligence and greed poison the Kalamazoo River and continues to pollute and destroy our land, they would be occupying these jails. Some may believe that if the penalties are severe enough, resistance to corporations who rape and destroy our planet for greedy, filthy lucre will falter and die, but they are wrong. From the hundreds of postcards we have received while in jail, our courage is only strengthened, others resolve to stand up to the real criminals. While Martin Luther King Jr. was in the Birmingham jail, he wrote, "We will have to repent in this generation not merely for the hateful words and actions of the bad people, but for the appalling silence of the good people." I don't pretend to know if it's about good people versus bad people, but I do believe it may be as simple as love versus fear. I understand what it's like to be afraid. I've spent much of my life in fear. But I stand today resolved, knowing that the consequences of inaction are far more terrifying than my fear of jail. Thank you.
Thank you, ma'am. Dick.
There are one thing. Mr. J.D. had indicated the fees on the other individuals that just have misdemeanor charges. I don't think they're relevant to these cases, but the records I have do not indicate that they pled to an attempt, that they pled to trespass. But I think they don't need to be in there either way.
All right, well, I just want to tell you, I consider that sentences whether everybody's individual lives to
Nothing further, Your Honor.
13 months probation, 130 Crime Victims Act fee, $118 state costs, $500 court costs, $10 a month oversight fee paid. The restitution, and Mr. Jakey, I know you already indicated that you wanted a hearing on that, so the prosecutor will set those amounts for testimonial hearing. The bond will be applied. 34 days jail, credit for 34 days on each of these counts. The defendant has a right to make an application for legal appeal. By doing so within 42 days, fill out the appropriate forms and file an appeal. She's certainly welcome to do that. Ms. Hamlin, you're welcome to
Your Honor, was there court costs for Ms. Hamlin as well?
I said 500.
500.
Did I say 500?
Thank you.
Yeah. I'm going to have to say it more emphatically. You're welcome. Thank you. That's all. Next.
Next, Your Honor, people versus Lissa Leggio.
Put your appearance on. Lissa Leggio, 13-918FH. I understand, counsel, that Mr. Covert is strangely enough, tied up somewhere else?
I got a phone call from Mr. Coleman yesterday, Your Honor. He indicated that he had a Section 8 hearing going on medical marijuana with Grand Rapids that had been scheduled to have an entry hearing and all kinds of witnesses. So he asked me to fill in today. I agreed to do that. It's Attorney Robert J, EP 55829. And I talked with Ms. Leggio briefly about that, and she was in agreement as far as I'm concerned.
Is that okay? Any problem with prosecutor? No. All right. Counsel, you have a report. Your client has had the same chance and you the same chance to review this that I've had along with the other documents that have been submitted.
Yes. Yeah, Your Honor. I did receive from Mr. Covert's office a pretty detailed sentencing memorandum that I'm relying on. I did look at the pre-sentence report, which I didn't have the opportunity to do before today. And I noted that Ms. Dixon has many changes on it. And I would just say for the record, it looks like on the sentencing guidelines, I'm in agreement with the changes. But I'll just have her read them since I don't have that document.
Just on the sentencing guidelines.
And on everything. I mean, we made a lot of changes. I'm in agreement with all correct, except the first ordinance and that's
First, on the face sheet, the defendant did have a prior, so it should be resisting and obstructing as a habitual second, which would make it a maximum of 3 years.
All right.
On page 2, under the jail
This,
credit.
okay, did we note that that was a half second at the time of the trial? Yeah, it's a half second. So all right, go ahead.
Next, Your Honor, on page 2, under the jail credit, they didn't give her credit from yesterday to today, so it should be through March 5th, which would give her 34 days in the last section, so total 36 days credit.
36?
Yes.
All right.
On page 1, under evaluation plan, in the first paragraph, the defendant was found guilty on January 31st, not January 27th. On page 2, under, I think that's still under the ages description, the second to last paragraph, just that we could add in that the defendant acknowledged she could release herself from the infraction.
All right.
I don't know. With respect to the restitution, I'm not going to read that down, Mr. Casey, but if you had it in consistent with the other defendants, the amount for which should take pleas should also include $1,051.60 for total replacement. No restitution being requested by Enbridge. Total restitution being sought $47,656.50.
All right.
Again, the conviction date for the instant offense, that's on page 6, Your Honor. On 8 of 8 of the history, it should be January 31st.
Got it.
And next, Your Honor, on the sentencing information report, it should indicate it is a habitual second. In the conviction information, Your Honor, as well, prior to variable, it says habitual, no, it should be second.
It's in disposition, right?
No, it's on conviction information. It's on the sentencing information report.
Yeah.
The conviction information, that first section, the last line there in the middle.
Habituals. No. Okay.
PRB 5 should be scored at 5. PRV 6 should be scored at 0. Total PRV is 10, still PRV level C.
Okay.
OB 19 scored at 10, giving us total OBs of 10, OB level 2, guideline range 0 to 13.
So JP, I know you're objecting. You're objecting to 19, right?
I object to 19 for the same exact reason as I said for I think we're right on that.
Well, the first time I admitted I was right. Dixon, any comment you want to put in a record on 19?
Nothing.
All right, well, we'll let the higher courts figure that out. Okay. Any other questions?
No.
Comment?
Again, I'm relying on Mr. Coleman's written sentencing memo, Judge.
Yes.
And when I read that, the same thing struck out at me as what I saw, and almost the same thing what I saw when I read my client, Vicci Hamlin. And then you have a young woman here who's had some difficulty in life, but I think she's made extraordinary gains from her past and the tragedy that she had as a very young woman with her parents, and losing her parents. She's a beautiful woman here that has a track record of, again, selfless service. I'm asking that you impose the same sentence that you've done with the other defendants in this matter. And she's got to do it to save her allocation.
You know, while I'm going to sentence this lady, I neglected on your previous client to indicate that no objection to a transfer to Indiana because of the mistake. Okay, I appreciate that. So we'll put that on. Would you like to say anything, ma'am?
I just want to wish you good afternoon. See, I know it sounds like a cliche, but I stand before you a changed woman because I am now a grandma. 7 days after incarceration, my daughter gave birth to my first grandchild. And I really can't tell you to have missed it. But I wanted to offer my sincerest apologies for the upset of our trial, that our trial caused. And while I cannot speak for anyone else, I know that no disrespect was meant. Many lessons were learned. And I humbly ask the mercy of the court that I may be released to tuck my 5-year-old son again.
I'm going to put on 13 months probation, 118 state cost, felony crime victims' rights fee of $130, 500 court costs, Ms. Dixon.
Thank you.
The restitution is reserved in the amount prayed for, Mr. J.P. Bond would be applied not to use drugs while the term of probation continues, and she's testing if needed. 36 days jail on each count, credit 36 days. The defendant has an absolute right to file a complaint to fill out the appropriate papers. 42 days. Wish you luck, man. All right, we'll take a short break. Anybody that wants to leave, want to stay and watch this for a while? Oh, wait, I got to hurry.